Right, Kate Floss. So Kate Floss coming in live. I'll just say hello. Probably you're all asleep. SOS, England, Scotland, Ireland, New Zealand, Australia. Our countries have been taken over by religious cults, and America, and all sorts of strange things have been going on. We've been fighting in the courts with the 1688 Bill of Rights of our ancient laws about, we've been fighting against foreigners being in our country, and we're trying to get some hold on our own governance. Our parliament in New Zealand has been taken over by more than 60% foreigners. We've recently had the Fijian army coming into New Zealand because we don't seem to have any army. I don't know where the army is, but we had a disaster in New Zealand. There don't seem to be any New Zealand army there. Well, there may well be, but I haven't seen them. And I did go to the court and take Jacinda Ardern-Andrew Little, several others to the court to have our 1688 Bill of Rights announced. And there's been a court ruling, and we've been appealing, but I think they've come in, and I think they're gonna. I haven't opened it, but I think they're gonna knock it on the head. I'll put some music on for you a minute while I go and get it all sorted out, and um, and then I'll be coming on. So I'll just leave the chat open for a bit, just in case somebody wants to come on. If there's anybody out there, anyone can sign into the YouTube and say hello and see. Then you can, if you sign into the YouTube, Sharon, you'll be able to see how many people are in and let me know what's going on. Are you able to do that? So sign into the Kate Floss YouTube. So the Oreo team, part of the Oreo team is with me. Half of the Oreo team's with me, and you can't see them, but I'll do the video with them on it as well, and we'll be videoing this as well. So I'm just going to be setting this up. I'll set it up over here. I'll set you up over there. Is that what I'll do? And then I'll set this up over here in the middle, so I can see all what's going on. And if anyone wants to come in and see Kate, we've been making a lot of videos, but we did go into the court. We've been fighting very hard. It's a little bit hard for people to know what we've been fighting about, but mostly what we've been fighting about is the abundance of foreigners that have been in our New Zealand Parliament. Now, England is currently governed by a Pakistani. Scotland is governed by a Pakistani. The head of our serious, this commissioner of our serious board office in New Zealand is Chinese. The chief financial advisor, who is threatening to take away our pensions for all that, he's very upset that the people that were born pre 1865 who had built these countries. We built all the roads, we built all the schools, we built all the hospitals, we did all that. Our ancestors did all that, and then so that we could have a pension and we wouldn't have to work too hard. Well, all of the refugees and immigrants coming in that currently outnumber the core population of New Zealand, that since they filled our parliament with foreigners, they also put foreigners in charge of our immigration. Well, so they put the fox in the hen house for sure. And then they've brought in more than around about 2.5 to 3 million refugees and immigrants who outnumber the core population. And those people have been in charge for immigration, and they have been bringing in the parents and the grandparents of the people that have been coming into work. And New Zealand is having to foot the bill for all of those. Through footing the bill for all of the dependents of the immigrants coming into work and refugees, there's not enough money for us, the people that built the country. We built those roads. We built the parliament. We built the hospitals, we built the waterworks, we built the forestries, built the fisheries. There is not a single thing on in these countries of England, Scotland, Ireland, Australia, New Zealand that we, the uh, German Protestants, with the native people of the land, there is not a single piece that we did not build with our ancestors with their bare hands, their bare blistered, bloodied hands, and people have just decided to come on into our country and say, I looked at my country and we didn't take care of ours, and I've looked over at your lovely countries, your 5 lovely countries, and we've decided that we're going to take it. That's what's going on. So we'll see what the court. I'll put some music on while I'm setting up the court ruling. It is the grasshopper and the ant story, although it's even worse because the it looks like the which one didn't keep the save all the staff and everything. Or was that the grasshopper? Was it? Yeah, but he didn't get it in the end, did he? But unfortunately, they tried. He tried, didn't he? And so they're trying exactly. They're trying. They're trying, and we're not just gonna lay down and let them take it without a fight. We haven't got guns, we haven't got anything like that, but we've got our 1688 Will and Mary, and we're gonna do our best to fight in the courts, fight through the courts, and go up against them all. Now put a bit of music on for a minute while I get this video thing set up. Suppose I should put on music. Oh, Maxine's here. Maxine's here. Hi, Maxine. It's me. When you die. All right, come on. Give us a good rolling. Right, we can do this. Be brave. Everyone be brave. Right, that's it. We ain't messing around here. Right, Maxine's here. Ah, she's laughing. Right, we're going to go in there. We're going to open up the ruling. Where's Sharon? Is she what? Sharon, are you there? Oh, I can't start until Sharon's here. No, no, but I want to. She can't see the when I open up the ruling. I hope she's around. Ask her if she's gone out. All right, she's on the YouTube. But don't worry about the YouTube, Sharon. Come back to the video, and then you can. I've got Maxine on the YouTube, so she's watching the YouTube and watching the comments. Right. So have you got your back there, Sharon? Right, there's Sharon. Hi, Sharon. Sharon, we're on record. So just remember that we're on record, mate. And so we're going to open up the ruling. Oh, dear Lord. So we're thinking that they're going to end all of it. We've had five write-ups in the New Zealand Law Information Law Society. We've had five write-ups. We've had a High Court ruling. We have had an appeals court ruling, and we've had a Supreme Court ruling. And we're coming back to this ruling here, which I think that this will also go up on the NZLI. It's got Cook J, Jacinda Ardern. So this is it says here, notification of judgment delivery. It's on the CA306. Oh, it's on the Judge Brown. It's not on the Cook J, because Cook J is a 616. This is 306. So this is Catherine Ann Sixtus first, Jacinda Ardern, Chris Farfoy, Andrew Little, and Ashley Bloomfield. And we had taken them to the court to say to them, we had called them to the court to say to them that they had not been upholding the 1688 Bill of Rights, and they had not been allegiant to the oath of their office. And then, as you all know, they went through a series of appeals and everything, but they wanted us to pay $7,000. But we've just let it sit there. We've been appealing, and then the Weather Act came out, Section 11, and in Section 11 it answered two of the prayers, prayer number 2 and prayer number 3. Prayer number 2 said that we wanted them to acknowledge and to make a declaration that our 1688 Will and Mary Bill of Rights is continues to be a part of the laws of New Zealand, and that we can use it in a court of law. Now that has already been established in the Weather Act, and then also we asked them to differentiate between the 1990 New Zealand Bill of Rights, which is not our absolute common law indubitable right, and differentiate between what is our 1688 Bill of Rights, because they have been sneakily piggybacking on that false law onto our genuine law, and they've been using it for nefarious purposes. So the Weather Act also did that for us. It did say to them that if you're using the 1990 New Zealand Bill of Rights, that is subjected to justified limitations, and any of the rights can be overridden by Parliament or by ministers at any time that they see fit. But they said the Bill of Rights 1688, or I call it the Will and Mary, which comes from 1688, the Glorious Revolution. The Glorious Revolution, when they put the Prince and Princess of Orange onto the throne. Now, this is very significant because King Charles III is about to enter his coronation. So this 1688 is key to this coronation, and it's great that we've been able to call it into the court. We called it into the court under Her Majesty Queen Elizabeth, and then she passed away midway through court hearings, and we had to flip it round and change it to be a petition to the king. So it's just all worked beautifully. And then I'm too scared to open it. And then so then they said that as for our Bill of Rights 1688, or our Will and Mary, it absolutely cannot be breached under any circumstances by the Governor General, by the Ministers of Parliament, nor by any of the entities attached to our New Zealand Maori peons. Now, our New Zealand Maori peons are a mixed blood, most of them are a mixed blood of European subjects and the original native people of the land of New Zealand, the original New Zealanders. They are a mix. So I've been calling them Maori peons because we get both. Now, they have got a lot of say. I don't think they're allowed to override it in regards to us, but they're allowed to override it in regards to the immigrants that have come in that do not have subject status, but they absolutely cannot override it in regards to us Anglo-Saxon people that were brought on the white slave ships 200 years ago. So All right, let's go and open it up. Are you ready? Sharon, where are you? I'm not going to open it without you. I'm opening, Sharon. So we've got the judgment of Goddard J. And it says between Catherine and Sixtus, Jacinda Ardern, Chris Firefoy, Andrew Little, and Ashley Bloomfield are the respondents. And applicant is in person, which is me, and Peter Gunn is for the respondents. It's come out on the 19th of April 2000. The application to review the Deputy Registrar's decision declining to extend the date for compliance with 43.1 of the Court of Appeal was declined. Now, you're all going to wonder what happened. Now, this is he's going to give us reasons, but I won't give the reasons because I'll explain first. So what has happened is so Cook J in the first High Court struck me out. We went to the appeals court. The appeals court, the Cook J, they said Jacinda and all them, they're not coming to the court. The appeals court said to them, you will come to the court and we will carry on without you. But then they hit us with the $7,000 in fees. I appealed that decision of the Deputy Registrar McGrath, and then that appeal, as soon as you appeal the registrar, that goes directly to a judge. Now, we did not, that first case was still sat there, and then I appealed the fees, then that went to a judge, Judge Brown, then that went, and I lost at Judge Brown over the fees, so I went to the Supreme Court and applied, and I was accepted at the Supreme Court, but they wanted $1,000, and I appealed that $1,000 because I said it's the right to petition the king, and it's the right to petition the king, and any commitments for doing so are illegal. The judge came back, that's Justin Allen France. We've got all the judges. I'll go through all the names of the judges at the end. So Alan France, whose lovely husband, bless him, he's just passed away, and he was a person that believed in the good weather, and I believe in the Good Weather Act as well. As he was recently passed away, that's her husband, that's Ellen J. Now, all these judges come from generations upon generations upon generations of families of lawyers, and they're all coming to see Kate Floss. So I'm feeling very proud. No matter what happens, I'm feeling very proud. Now, so then the Supreme Court said, however, Ellen France said at the final result, she said, if you want to continue your appeal against Judge Brown, please come into the court and pay the $1,000, which we're going to pay this week, right? So donations, everybody. So then I said to the Supreme Court, would I be able to put that on hold for a moment while I go to England, because I was going to go over to Westminster. I called up the Westminster, and they said to me, New Zealand left the King and the Queen in 2003. Now, that was done by Jeffrey Palmer and Lord Cook. They are the ones that took New Zealand, it removed New Zealanders' right to petition to the Privy Council. Now, who turned up in my first court was Jeffrey Palmer's son, Matthew Palmer, and Lord Cook's grandson, I think, either grandson or son, Francis Cook, turns up in the first case to me. So the Westminster said to me, no, We don't want anything that is sent to us from New Zealand. We will send it back. We will not even let you pass the registrar. We won't even send it up to the judges. I said, well, I came on a ship, and my agreement was with my German settlers ordinance from the ship between my ship and Queen Victoria. So I said, I'm going to petition from the ship. And the registrar said, we don't take petitions from ships either. So that was a bit of a funny. And then because I had done that, JC McGrath, the first case, she deemed it abandoned because she said that I was not appealing but only intending to appeal to Supreme. So she deemed it abandoned, and then this is the ruling for that. So this means that he's declined he's declined the abandonment, and he's going to give us reasons. And then once he's done this, I can then appeal to Supreme Court. So this will go to Supreme, and we've still got Judge Young. So listen, it ain't over until the fat lady sings, and I'm not fat enough yet. So I'm going to be still doing this. Now let's go to the reasons background. Ms. Sextus commenced proceedings in the High Court against Ms. Jacinda Ardern and others. The proceedings were struck out as an abuse of protest under 5.35b of the High Court Rules 2016. Cook J found that the claim as pleaded was unintelligible. They said Kate Floss is unintelligible. I think I'm not that unintelligible. Actually, if they're taking my request and putting it into New Zealand legislation, I'm saying I wasn't that unintelligible. To the extent he said that it was, and he's got a spelling mistake. Oh my gosh, Judge Goddard, you can't even spell. Yeah, Maxine says, you're right, Kate, it's not over until it's over. We're going to keep moving ahead. Yes, we are, Maxine. This will go to Supreme. We're going to have a long list of Sextus names just lined up there. So we're still in the courts. I think they just like me. Now look at this. He's got a spelling mistake. He said, Court J found that the claim as pleaded was unintelligible to the extent, they say, that it was possible to discern the allegations made. But what it should say is that it was impossible. But they've said it was possible to discern. So I swear, but if I could, I'd be saying all the F words 5 times. Sharon, who's unintelligible? Hey, listen to me. Here's what he says. Cook J found that the claim as pleaded was unintelligible to the extent that it was possible to discern the allegations made. I'm going to cut and paste it for you, Maxine. The silly twat. I'm sorry, Judge Goddard, but you are a silly twat. Who's unintelligible? Court J found that the claim as pleaded was that it was possible to discern allegations made, meaning they knew exactly what I was talking about. It's a Freudian slip, Sharon. And it's a Freudian slip. Maxine's laughing. She's laughing her tits off. She's laughing. You silly twat. I can't even stop. How could he even write that? Right. Judge Goddard, I hope you're watching. I hope you're watching because you've just said to me that my pleading was unintelligible to the extent that it was possible to discern the allegations made, which is a fraudulent slip. They knew exactly what I was talking about. They knew exactly, and the good Lord from above was watching. And this is what Jesus said to me from the Bible. He said, "Don't worry about what you're going to say because I'll be speaking for you." And obviously, the good Lord will visit Judge Goddard, and the good Lord said to Judge Goddard, he said to Judge Goddard, "You know exactly what she was talking about, and you've lied and said she was unintelligent." I'm going to put that on Facebook. It's going up on Facebook. I'm gonna make a whole big slide with lots of lovely. I'll put the scales all around it and a picture of Judge Goddard, and I'll put it in the newspaper, and I'll say, "And you said that I was unintelligible." Well, how funny. So, let's continue to see, what else he had to say. Cook J found that the claim as pleaded was unintelligible to the extent that it was possible to discern the allegations made. Many were not made within the jurisdiction of the court. These deficiencies were too fundamental to be capable of being remedied by an amendment. But we can dispute that, but we'll leave that for the moment, right? Then he goes on to say, on the 21st of June, Ms. Sextus filed an appeal to this court against the High Court decision. She applied for a waiver of the filing fee for this appeal. The deputy registrar declined that application. Ms. Sextus applied for a review of that decision. On the 12th of August, her review application was declined. Under R43 of the Court of Appeal and the 2005 rules, Ms. Sextus was required to file the case on appeal and apply for a hearing date within 3 months of filing the appeal, failing which the appeal would be deemed to be abandoned. Rule 43 provides for that date to be extended in certain circumstances. In particular, it can be extended by the registrar for periods up to 1 month under R43 in certain prescribed circumstances, which the Registrar McGrath, I would just say that Registrar McGrath has been absolutely fantastic and has always reminded me that I need to renew the extension, and has always been in conduct. I don't know if it's a Judge McGrath, but JC McGrath has never erred in being helpful. I haven't agreed on her rulings, but in regards to her honour and good governance and good works down at the court, that she absolutely cannot be faulted at all. She's done everything according to the law. Some decisions I don't agree with, but I can still see her point of view, which is not in line with my point of view. But JC McGrath, great. So my extensions were rolled over every month. And then, in particular, it can be extended by the registrar for periods up to 1 month in certain prescribed circumstances. Mayor Sextus advised the deputy registrar that she would be appealing this court's decision on the fee waiver to the Supreme Court, that she would be in light of that advice, the deputy registrar extended the date prescribed by 43 of the rules on a number of occasions, and yes, she did, always extended for me. On the 3rd of October, it was extended until Monday, the 31st of October. On the 31st of October, it was extended to Wednesday. So from Monday, it was only extended 2 days. And I was very unprepared for this. Now, I am a layman, and I'm not a lawyer. So I did make a mistake here. On the 30th, let's see what he says. On the 30th of November and on the 28th of November, it was extended to Wednesday, the 25th of January. On the 24th of January, it was extended to Friday, the 24th of February, right? That's just all the lists. That when you don't hear from me, these are all the lists of all of the things that I've been doing and how busy I've been trying to do this case. But obviously I haven't done too badly because the courts are genuinely working with me all the time. They've been, as long as I stay within their laws and work within what they're talking about, they've been very, very good to me. Meanwhile, Ms. Sextus had applied to the Supreme Court for leave to appeal from this court's decision, which I've done. She sought a waiver of the filing fee for an application for leave to appeal. That application was declined by the deputy registrar of the Supreme Court on the 11th of November 2022. Ms. Sextus applied for review of the deputy registrar's decision. On the 1st of February 2023, the application for review was dismissed by Alan France. That was on the $1,000 entry into the Supreme Court. So they'd said, yes, you can enter, but pay the $1,000. But the whole case is balanced on fees because I think that we should be allowed to call the Parliament to the court and we shouldn't have to pay. Since how come the New Zealand Maori allowed to go to the Waitangi Tribunal on any issues to do with 1840 up to 1975, even through they're allowed to go to the court, the Waitangi Tribunal, on any issues, and they are permitted to get a free lawyer to assist them in all their research and all of their case. It's all done freely and it's paid by us. So, and then they said in New Zealand, to those from overseas, they call us Pākehā. But we're Anglo-Saxon people that were brought on the white slave ships of the St. Pauli in 1844 from Germany. And we have been told that we are not allowed to go to the Waitangi Tribunal. Now, the refugees and all the immigrants on the 1990 and the Human Rights Commission, they are allowed to enter our court for free. They are entitled to a lawyer. They are entitled to a translator. They are entitled to have every document translated into their own language, costing thousands of dollars. And that's to fight their right to stay within New Zealand. So we pay for all of that. Not only that, if any of their rights get violated or overstepped, they're entitled to a free New Zealand lawyer to enter the court and apply for compensation, which we pay for. The citizens' advice only accepts New Zealand immigrants and refugees, and then they have from 5 o'clock to 7 o'clock every single day, they have classes where the immigrants and refugees can go there for free and get free legal advice on any issue that they want. The Otago Law Society has pro bono lawyers available to any rights advocate for the human rights of the United Nations, all of that. That's all provided for free, and it's all supported and paid by us Anglo-Saxons that are not allowed to enter the court without paying thousands and thousands of dollars. This is what I'm fighting here. I'm not saying that, hey, I'm a special little Anglo person and I should get it free. I'm saying that every group in New Zealand is permitted to go. The handicaps have got it. The homo promos have got it. The ethnics have got it. The refugees have got it. The New Zealand Maori have got it. The Pacific Ka have got it. The Islanders have got it. Everybody's got it. The only ones not permitted to get any legal assistance unless we're a criminal. If we're a criminal, we're permitted to get a legal assistance to help us through the courts so that courts can put us into prison and make us pay fines. But if we want to go to the court in regards to our 1688 indubitable rights, we have to pay thousands and thousands of dollars to do it. So that means the government has got a free hand to do anything they like to us. So that's what I've been fighting. So I didn't want to pay the fee at the Supreme Court because that is the whole core of my case. Well, get back to here. She sought the waiver of the filing fee, and that application was declined by the deputy registrar. That was Justice Greenbaum of the Supreme Court, and then that went to the Supreme Court Justice Ellen France, who, bless his heart, her lovely husband has just passed away. I'm sorry, Ellen France, but that has happened for you. And they've been married for life. They met. I'll just say a little bit about Ellen France. Her and her husband met at the university, and they've been married ever since. And he said he always followed her decisions. And she did make a very good decision, actually. Even though I got declined, she made a very good decision. I totally, absolutely understood everything that she said to me, and I took it on board. But she said, do come back to the court. The judgment records that if Ms. Sextus wishes to have the application for leave to appeal accepted for filing, she must first pay the filing fees. They've said, yes, come, but pay the filing fee, which we will immediately do. Ms. Sextus asked, oh, look, he's put it all in here. Ms. Sextus asked the Supreme Court for an extension of 3 months to pay the filing fee. On 9th of February 2023, the registrar of the Supreme Court advised Ms. Sextus both that there is no provision in the Supreme Court rules to extend the time for payment of a filing in these circumstances, and that her application for leave to appeal would be accepted for filing upon filing fees. So yes, the Supreme Court said they haven't got any rule against you asking for the extension. So they said, when you pay the filing fee, just come on in and let us know. So there's no rule. You can pay the filing fee whenever you like. There's no actual rule. There's no time limit of when you can pay the filing fee, which is, that made me a little bit confused because it's not the same in the appeals court. And so I had messed up. That's why my case got abandoned. On February the 23rd, 2023, the Deputy Registrar of the court advised Ms. Sextus that because the application for leave to appeal to the Supreme Court had not been accepted for filing in that court, there were no grounds under which the Deputy Registrar could grant a further extension of the rules. The Deputy Registrar advised Ms. Sextus that if the filing fee was paid to the Supreme Court by the 24th of February, say, and the application for leave to appeal was accepted for filing, a further extension could be granted. Now, I only had 1 or 2 days to do this, and then I had applied to her for extension on that, and when it got turned down, I'd lost it. So otherwise, the date prescribed for the filing fee and appeal and applying for a hearing date to avoid the appeal being deemed abandoned would remain. So exactly on the 24th of February, the appeal of the Ardern si was deemed abandoned, all right, sadly. So, well, it's all kind of worked out. Mayor Sextus requested a further extension on the 22nd of February. See, I only had 2 days. I did request for the extension on the 26th, but the Deputy Registrar declined to grant the further extension of the rules on the basis that she did not consider there were currently grounds to grant the extension. An extension could be granted of the rules only if a party is seeking leave to appeal a decision of a judge of this court. So if everybody understands that, what it means is, if I pay at the Supreme Court, then I am seeking leave to appeal. In fact, if I ask for extension at Supreme Court, that's got nothing to do with appeals court, and therefore I don't get the extension down there. Even if I get the extension up there, I don't get it down there. But don't worry, because JC McGrath has told me that I've got until the end of, I'll have to go and look, but she's given me a date that I can still appeal this decision. And if I am actually in the Supreme Court and then I come back here, it could all ramp up again. It's not the end. So it's just a matter of, they're basically saying to me, we don't know, are you a tire kicker? They're basically saying, are you a tire kicker? That you're going to mess us around here with all these cases, and then if you lose, you're not going to pay, and then we'll be left flat, wasted our entire time with you. So what we've got to do is show good faith, and I'll go and pay it, and we'll enter, and we'll have to fight the filing fee with Judge Brown. And then when we're actually doing that, we can then still apply to let them know that we are still seeking that leave. So they may or they may not decline. Mayor Sextus was not seeking leave to appeal. Rather, the Deputy Registrar said she was only intending to seek leave to appeal. Mayor Sextus also sought an extension of time under 5A. I know what these are, but don't worry about it. The respondents did, and the respondents see under 5A1C, you can ask for an extension of time, but if you do that, in that case, the respondents have to agree, which is Jacinda Ardern and Ashley Bloomfield and Andrew Little. And Peter Gunn, who is their lawyer, they would have to agree, but they did not. The respondents did not consent to an extension, so the registrar could not extend the time. Now, take note here. I'll just make sure that I say to everybody, nobody, in my case, nobody has committed any crime here. They're called respondents. That's because we've only asked a government official to come into the court to answer our questions of law if they are upholding the oath of office of the Cabinet Manual. That's what we've called them in. And we haven't said that anybody's broken any laws. We've only asked them in because we want to give them questions about how they're upholding our 1688 will and Mary, which is part of the Treaty of Waitangi. And so the application for review of the deputation application, so then I got declined, right? Is everybody up to speed? Got declined, and then I made an application to review the registrar's decision to decline my application to extend the appeal. You can see why I'm busy, people, can't you? So Ms. Sextus now applies to review the Deputy Registrar's decision. Then it says the appeal is abandoned if it is not pursued. But what I had said to them is I am pursuing it, because I said to them, so it says the appeal is abandoned if it is not pursued. And I said, well, asking the Supreme Court for the extension and having that agreement is evidence that I am pursuing it, but I just was not ready to come in just now because I still had some stuff to do. That's what I said to them. I thought that was a good argument. So, so they've got all that there. That's just the law there. So now he's gone on to explain to me. The judgment of Alan France made it clear that if the application for leave to appeal was to be accepted for filing, or I hope I'm not going to get bad news here, the filing fee must first be paid. That was reiterated by the Registrar of the Supreme Court. Ms. Sextus acknowledges that the filing fee has not been paid, so there is no live application for leave to appeal to the Supreme Court. Tell me you're going to surprise me here with something good, Goddard. Ms. Sextus submits that her application for leave to appeal has not yet been determined because she has written to the Supreme Court asking for an extension of time of 3 months before formally paying the fee. She also refers to extenuating circumstances arising out of the COVID-19 pandemic. He says, however, I consider that it is clear that in circumstances where Ms. Sextus' application for leave to appeal to the Supreme Court has not yet been accepted for filing, he says there is no live application before the court. Now let's see what he's going to say. In order for 43B to apply, there must be a live application for leave to appeal before the Supreme Court, which has not yet been determined or was determined within the previous month. In the absence of a live application before the Supreme Court, the question of whether and when such an application has been determined cannot arise. So what he's basically saying, until I pay the $1,000 and birth my Supreme Court case, it becomes a live case. Until I make my case is a dead case, it's considered a dead case, until I enter it into the Supreme Court and it becomes a live case, then they in the appeals court cannot determine if I should get the extension or have the appeal unabandoned. So what they've basically done is released everybody so they can go about their business while Kate Floss is fluffing around with all of her things. Now let's see, might scare me here. It follows that the Deputy Registrar was right to, and I kind of agree, was right to conclude that Ms. Sextus did not come within 41B. 41B is just saying what he's just said, that you have to have a live application in order to get the abandonment overturned. The Deputy Registrar had no power. She's working within the law to extend time under 43B, so was right to decline to do so. She could not do anything else. And now that he's put this so clearly for me. I can really, really understand and comprehend what he has said in the position that I have put her in, and she could do no other thing. The application for the review of the Deputy Registrar's decision must therefore be declined. The application to review the Deputy declining to extend the date of the rules is declined. So I'm going to accept that, but I believe he's left me a little bit here, because it basically says if I've got a live application. So what will be the next steps to this? The next steps to this will be that we'll just leave this one sitting here, and JC McGrath has said that I can appeal this, right? So if I went in and entered on a live case, right, and then we would wait to see what is the result. If I lost that live case, I could decide to just drop everything. Or if I lost that live case, I could decide to go back, and probably what I would be able to do is I would be able to say to the appeals court, I have the $7,000, I want to pay it, I have finished my appeals at Supreme, it was a live, they might be able to extend it, it was live, and then I may be able to enter back in, but they basically have said to me that we're not going to fluff around anymore until we know what you're going to do, that you're serious, that you're going to be coming, because it's a waste of their time and it's a waste of their money if I do just decide at the final frontier to just dump it. So I'm very accepting of what they have said to me, and I'm here to tell you, I don't agree with their decisions on fees. I don't agree with them that it was unintelligible, and but that's got to be fought out in a court of law, which it has not been done just now. It's only been so I've got the judgments of many good judges, and they've all given me extremely valuable advice, and I can use all that when I go through to see Judge Brown, and I'll be able to speak to each one of the judges. And what I'm going to be able to do is to look at the pieces, the important pieces that they've given me, and refine my arguments to their refined arguments. So they refine it all down and they give me the information. So I've got information from Alan France, I've got information from Judge Brown, and I've got information from Francis Cook, and I've got information from Goddard as well. So I can condense all of that and try to make a reasonable case when I get to the Supreme Court. So it's definitely not over. Does anyone have any questions on all of that? I suppose you won't. Anyone? Maxine? So nobody's got any questions. Right, so I'd be interesting to see if this comes up in the NZLII, because it'll be another tick for Kate Floss. So there's going to be a long list, and also we did have a bit of a laugh because poor old Judge Goddard. I thought you can petition the king. Yeah, exactly. That's what Maxine's saying. She says, I thought that you can petition the king for no fees. That's what the argument is. And that's exactly going to be the argument that we need to go to the Supreme Court. We need to say to them, it says here that we can. And I'll say to them, they have not answered to that, Maxine. Was that not what we were fighting for when we went to fight for the fees? Exactly. That is exactly what we're fighting for, is the fees. But I'm saying that the fight for the fees is still not over, Maxine. We still have got to enter the Supreme Court on the fees and go to court up against Judge Brown. And then if we win or lose, if we lose on the fees, that's the end. If we lose on the fees, then that'll be the end of the argument, because it will be a Supreme Court ruling that you cannot get fees on the 1688 waived. So Alan Francis already told me what is the point that I have to argue for that. She's already said it. And then Judge Brown has already said, Judge Brown said, you're a citizen and you're not a subject. So he has said that. And then Alan France has said that the appeals court, it does come back to what I first said, J.C. McGrath, this is where I'm going to say that J.C. McGrath at the very beginning, when she made her ruling about the fees in the very beginning, she said that what we were fighting about using the 1688 in the first court was nothing to do with the appeals court. The appeals court was only concerned with the strike and was not concerned about any arguments in the reasoning for the strike, why we went in. And I think it was very one-sided. And Alan France agreed with J.C. McGrath. So there's quite a few arguments going on here. I know what's going on. I really know. So we still got to, we're not out yet. We're still going up to the Supreme to fight fees. We're still fighting fees, Maxine. And I just will go through the list of judges. I believe there's not a person on earth that has had the judges that we've had. I'll go through the names, and if anybody's interested, you can Google them, and you will find out that old Kate Floss has had the best legal minds at the table with me from start to finish. I have had Matthew Palmer, the son of Geoffrey Palmer, who wrote the New Zealand Bill of Rights and who pushed to leave the right to petition to the King in the Privy Council, pushed to have that eliminated. His son was in the High Court. I have had Judge Francis Cook, who comes from both of them come from families of lawyers that date back generation after generation. And Judge Cook, his father or grandfather, maybe it's his grandfather, who was working on the Muldoon case of the 1688 Bill of Rights way back in 1976, Lord Robin Cook was the only New Zealand judge ever to be ascended to the Privy Council as a lord in England. He was the only one. So I'm not sure if it's his son or his grandson, and it was him that worked together with Geoffrey Palmer to remove our right to petition to the Privy Council. So I had those two sons at the first High Court. JC McGrath, the registrar, has worked impeccably with me, and never once has she failed me. I've not agreed with her, but she has treated me with nothing. She has treated me respectfully and absolutely done a great service. Well, to my knowledge, if it's the right JC McGrath, she comes from a long line of Supreme Court judges and all of that. And then that went to Judge Brown. I haven't done much research on Judge Brown, but now that I'm going to be taking him to court, I will have to be doing some research. After that, I got a person called, well, his name's not on here, so I better not mention it. But I appealed him, and then I got Ellen France, and her husband are both Supreme Court judges. He's just passed away. They come, both of them are the toppest judges in the land, come from a long line of generation after generation of judges. And now I've come back down and I've had Justice Goddard, and I think I remember that name. So we'll have to go and research Judge Goddard. But let's just all remember, let's just all remember Judge Goddard, one of the finest judges in the land, did say to me, Cook J found that the claim as pleaded was unintelligible to the extent that it was possible to discern the allegations made. There's a Freudian slip. Wasn't there, Sharon? There's a Freudian slip. And we better go. I can't even believe that, because I've got it. They can't take it away from me. Oh, I better download it and put a copy on. They can't take it away from me. It's mine, and it will go down it's going to go down in history. What Judge Goddard said on my court ruling of the Prime Minister Jacinda Ardern, it's going to be the most famous quote of all time. They're going to be quoting it for generations to come, because it was done on a Prime Minister of New Zealand's ruling. So thank you, Judge Goddard. I'll probably be doing magazine interviews and newspaper interviews any day now. So thank you. Right, that's it. I'm going to turn off the video here. Nobody's got anything they want to say special, right? Right. Maxine says, well done, Kate. It's been over a year of constant slog, and you got to Supreme 3 times. Gotten to Supreme 3 times. Yes, because this will go also. So it will. So, oh my goodness. I'm feeling happy. I'm feeling very happy. Yes, Maxine says exactly. I'm feeling happy. The ruling was perfectly reasonable, perfectly understandable, and the judge has been correct in what he said to me. And what he's just basically said is, you haven't got a live case yet, but he's also tongue-in-cheek said, if you did have a live case, we might reconsider it. So we better get that live case going. Oh, goodness me. So have you got anything to say now, Sharon? Say something. Come on. Say a little bit. Go on. She's just laughing. Sharon's just laughing. It's a whopper. called God. Judge God. Aaron, why didn't you say he's called God? I missed it, Sharon. He's called Judge God. He's called. So he's called Judge God. So for those of you who don't know, they said my case was unintelligible and they couldn't understand it. And Judge God came in and God said, and God said, Cook J found that the claim was unintelligible to the extent that it was possible to discern the allegations made. They understood it all right. Too right they did. Because then they wrote the Weather Act a few weeks later. They wrote the Weather Act and they put that 1688 and they differentiated between the 1688 and the New Zealand Bill of Rights. They have, and they've done it, and they certainly did discern the allegations that I was making. They certainly did, didn't they, Sharon? Well, because God said, ah, yeah. And God came in and he said, we were able to discern the allegations that you were making. That's what he said. I didn't say it. He said it straight from his typing machine. God said that they could discern the allegations made. He said it was possible to discern the allegations made. Well, let's look up Judge Goddard, Sharon. Hang on. No, I'm leaving YouTube on, and nobody's come on, but I just leave it on. And I started recording another. I turned off the other recording, but I've started again because I didn't know that it said God, Sharon. So let's look up God. What's his name? Judge. Let's see how clever he is. Judge, Judge. And isn't it amazing that they sent in God, Goddard? His name's God. And God said that it was possible to discern my allegations. It's going so oh, Judge, she's a woman. Sharon. What's Maxine saying? She's a woman. How could you that she's a dame? I've got a dame God. Dame God said, Kate Floss, it's possible to discern your allegations. No, that's Alan France in the Supreme Court, whose husband passed away, Maxine. Alan France in the Supreme Court, her husband passed away, But this is Lowell Goddard. Lowell Goddard and Lowell Goddard and Lowell Goddard, she's a dame. I've had the toppest judges in the land, and now I've had a dame come in to say, Kate Floss, we understand everything you've been saying. Maxine says you've had too many bloody judges to keep up with. Well, that's right. But I reckon they're all having a bit of trouble keeping up with me. Aren't they, Sharon? Oh, that's what Maxine says. She is a former New Zealand High Court judge from 1995 to 2015. She is thought to be the first person of. She's a Maori Pen. Maori Pen, let's introduce her. Judge Goddard, we would like to introduce you to the new word of Maori Pen, which we want you all to recognize your lovely Anglo-Saxon side. And she was appointed to the High Court in 1988. She was one of the first of two women to be appointed. She's Queen's Counsel down there in the appeals court with Kate Floss. And in 1989, she became the first woman to hold a crown warrant, whatever that means. What's a crown warrant, Maxine? In 1992, she was a deputy solicitor general for New Zealand, coming down to the lowly appeals court to give a ruling for the wonderful Kate Floss. I love you, Noel Goddard. Thank you for, well, I feel honoured. Sharon, do you feel honoured? And between 2000, I can't believe it. Between 2007, 2012, she chaired the New Zealand's Independent Police Conduct Authority. In 2010, she was elected as an independent expert to the United Nations. Well, Lowell Goddard, Dame Lowell, you have made clear in your ruling that it was possible to discern the allegations made against all you people, wasn't it? You know exactly what I'm talking about. It's a Freudian slip. Freudian slip by the gods. She was on the subcommittee on the prevention of torture, which was in my case that I was talking about, that we didn't want to be having torture and stuff. And she served in that capacity till 2016. From February 2015 to 16, she chaired the independent inquiry into child, I don't like to say those words, into child molestation, the molesting of young children. She was in England and Wales. England and Wales. She was born in Auckland. She's a Ngāti Kohangunu, Te Aitanga Makaki and Ngai Tuho. Her father was a squadron leader at Vaughan Goddard. She was educated at the she's a Catholic. Well, it doesn't surprise me, Dame Goddard. And then studied law at the University of Auckland since. Geez, have you ever known anybody to get that many judges, that many famous? I have had the most famous judges in all New Zealand taking care of me. I just love them. She was admitted to the bar, the victims. She and C.N. Elias set up the wholesale of New Zealand to the Pacific Islands. So she's with Cian Elias. Yeah, yeah. Doesn't I'm just flabbergasted that she would be. Well, she's married to John Scott, Sir John Scott, who is a baronet. What's a baronet? Tutor child. All right. Not Norm. Keep smashing it to them. Oh wow, Norm. You've had too many bloody judges. Um. Oh, Norm. That's that. Never mind. Whatever. Um. She's also the vice president of the International Equestrian Federation. So, oh my gosh, it just does not get any better than that. Had the toppest judges in all the world, the top judges in all the world. These people come from the best families. I think I'm going to get a T-shirt and I'm going to put a list of all the top judges that took the time. I'm just going to say thank you to all the lovely judges that have taken the time. They've listened to me, they've heard me, they've come back and they've given me their arguments. I haven't got everything I've wanted, but they've explained a lot of stuff. Some stuff they've avoided, but I'm hoping to get that cleared up in the Supreme Court when I go to talk with Judge Brown. But you couldn't have sent me a better judge. They sent God to see me. And so God's watching over us. There's no doubt that God's watching over us. And it might have been a deliberate Freudian slip, or it may have been undeliberate Freudian slip. May have been quite deliberate when I look at all around. So they all know what I'm talking about. And so I think a lot of good things are going to come out. I'm ever so proud that you've been with me, Sharon, and Diane and Maxine might have gone to bed. Not Norm has been in, but he's gone to bed. And although Norm, I'm not your sister. I'll just have to say that to you, Norm. I'm not your sister because I only just met you on YouTube. So I'm sorry, Norm. Sorry, Norm, but I can't be your sister. Can't be your sister because I already have 5 brothers, though one is dead. All right, Sharon. Oh my God, I can't believe it. Right, that's the end of our YouTube. And finish the YouTube. Goodbye, YouTube. End stream. And then that's the end.